In 1954, a committee chaired by University Vice-Chancellor Sir John Wolfenden and comprised of a worthy mix of judicial officers, politicians, medicos, ministers of the Crown and a Vice President of the Girl Guides was convened to examine the laws relating to homosexuality and prostitution. Reporting 3 years later, in 1957, the committee recommended that consensual sexual activity between men in private should be decriminalised, a recommendation that was not acted upon until the 1960s in the United Kingdom and followed elsewhere, including Australia, in the following decades. The committee argued that it was not the duty of the law to concern itself with immorality as such. The function of the criminal law, it said, was to preserve public order and decency, to protect the citizen from what is offensive or injurious, and to provide sufficient safeguards against exploitation and corruption of others, not to intervene in the lives of citizens. The report sparked a famous debate which commenced in 1959 with a lecture by Lord Patrick Devlin, a distinguished judge, entitled "The Enforcement of Morals," in which he argued that the criminal law is not just there for the protection of individuals, but for society as a whole, its institutions, ideals and morals. Responding in 1962, Professor Herbert H.L.A. Hart, as he was known, Professor of Jurisprudence at Oxford University, in his now classic series of lectures published under the title Law, Liberty and Morality, Hart argued, following John Stuart Mill, that unless something is harmful to society, the government has no right to interfere in the lives of its citizens. The debate continued in a series of publications for a number of years through the 1960s. There was never a face-to-face debate as there will be today. And though it took place over 4 decades ago, the issues raised in the debate are still crucial and significant. Homosexuality, abortion, drugs, pornography, prostitution are all still at the centre of political debate, particularly in the United States, where the respective realms of law, religion and morality remain in a state of flux, and where presidencies can be won or lost depending on the strength of feeling, the number of votes cast on the day, rather than on the force of argument or logic. The legalisation of homosexuality and the regulation of prostitution in the years following the debate did not mark a victory for freedom over oppression or justice over law. They were merely way stations in a continuing debate about human rights, individual liberties and the role of the state. Today, the contending philosophies meet face to face.
We are going to prove 3 things to you today. The first is the law should reflect generally shared public morals, including even in situations where harm to individuals is not at stake. Secondly, we will show that it is the source of the law's legitimacy and a true expression of the criminal law's role to protect all of society and not just the collection of individuals that comprise it. And finally, we will show you that public morals can and do change, and when they do, laws should move with them, but not before. I'm going to speak to you about 2 things today. The first is that social order requires laws to reflect privately held moral beliefs, not just things that hurt people. The second thing is that the public needs to believe that the laws will protect their private morality, not just protect them from immediate harm. To my first point, social order requires the law to uphold shared morals. It's almost axiomatic to say that laws should protect the community. Everybody would agree with that. We think that to properly do so, laws must regulate matters which don't just cause harm, but which challenge accepted moral norms, and we think that there are 2 primary reasons for that. The first is a very utilitarian one. We think that regulating shared social morals actually prevents potential harm. The Wolfenden report concluded that the law's function is to preserve public order and decency. We think that you need to regulate on a moral basis as well to do that. Why? Because the law's function isn't just to prevent harm, but to set the moral standards that prevent it as well. Let's take as an example incest. It's conceivable that there could be an entirely consensual, harm-free, incestuous relationship. But the law, as it stands and as it should stand, prohibits all forms of incestuous relationships and upholds a norm against that. We override individual liberty. Why? Even in situations where no one gets hurt. Because our society and the law which represents it sees a value in preserving the family unit where key relationships are sex-free. We think that that is essential to the moral fabric. In some instances because it prevents the kinds of harms that could accrue, but more generally because it prevents that relationship from ever becoming an unhealthy or negative one. Let's take a second example of animal cruelty laws. Yes, it's probably true that legislators care about animal rights and that's why they've passed these laws. We think it's as likely, however, that the point of cruelty to animal laws, or laws that prohibit that, is to uphold society-wide norms against cruelty and violence per se, regardless of who they're against. We think legislators aim to create a society in which individuals do not and cannot follow their wishes to cause harm to a sentient being. We think that the law should do those things. It should set those norms, even if no one immediately is harmed by that, to protect all of society. So that was the utilitarian reason. It protects social order and it prevents crime. But there's also a communitarian reason over and above that one. Even if the law isn't seeking to prevent harm, we think that laws should uphold morals to preserve integrated communities. We think that what creates a strong and successful community is a common set of values that underpin it, and the knowledge that there is a common set of values that we share, that we're all going to abide by. A community without that belief, we believe, is worse off. Not necessarily that a community will crumble without shared moral norms, but that it is worse off as a community, as a society, than it could be. We think people are less trusting, people are less integrated, and people have more fear and more caution if those shared morals are not there and are not reflected by the law. A sense of proper community, therefore, relies at least in part on laws upholding moral norms so that everybody knows what the accepted standards are and everybody knows that everyone else will be upholding them as well. It's not just enough to know that your belief that incest is damaging and dangerous will be upheld within your family. We think that it's more important that you know the entire community has adopted that view, that you can trust that as a view, and that you live in a community of like-minded people. We're not saying that society would collapse if the law didn't uphold all morals. We're not saying that if gay marriage were allowed tomorrow, that harms would accrue. It's not saying that each individual deviation from moral norms causes harm. What we're saying is to recognise that a functional society involves moral evolution, right? And we have systems to ensure that. We have polls, we have elections. But a society in which generally held private moral beliefs are not reflected in laws would be a society with a weaker community, and a society in which people feel like that community is weaker because of it. That is a harm in and of itself that the law should seek to prevent. Now, Professor Hart criticises this argument. He says it's tautologically equating a society with its values, but we think that's fine. We think that's fine because, as Lord Devlin himself said, society is something more than people living in proximity to each other in a state of peace. We completely agree. Shared values provide a basis for integration, interaction, trust, and an interest in society over and above the atomised individual. The law should reflect shared social morals to prevent harm or potential harm, but also to preserve the full function of society. To my second and final argument, the public needs to believe that the law will reflect morality as well. The law sources its efficacy from the consent of the people, both in principle and in practice. Social contract theory justifies the state using its coercive power against individuals through mutual implied consent. We give over some rights, we give over some freedoms in exchange for being protected and having certain gains. We think that it is entirely reasonable that the public would only, and in fact should only, consent to the rule of law if that comes with the rule of law upholding the things that they consider values, that they consider important, and that they consider morally right, even where that doesn't hurt people. We think that the legitimacy drawn from social contract would fail to exist if the law did not actually reflect the basis upon people would enter that contract. We think that also manifests practically. If people feel the law doesn't protect or reflect their values, then their adherence to the law is challenged. Now, this adherence is crucial because there's never going to be enough police officers to make each individual person follow the law. There's never going to be sufficient threat of sanction to believe that every instance of deviation from legal norms will be acted on by the state. We think that there needs to be voluntary adherence to the law, and that is much more likely if people feel like the law reflects their individual values and the values of their community en masse, more than just protecting them from immediate harm. Conversely, the greater buy-in that the public would have into the legal system would increase the amount of adherence and voluntary compliance with the law. But the other side of that is also true. The other side of reduced public faith in the legal system is the potential for things like vigilante behaviour. If the public considers something wrong and the system does not sufficiently respond, then the public may challenge the state's monopoly on coercive force. You need only look to a 2007 example of a pedophile's house being burned to the ground in Maringar Valley in Victoria. That's an example of people feeling like the law didn't reflect what they considered right and them taking it into their own hands. What have I told you today? Two things. Firstly, if you think the role of the law is to protect the public, then that involves more than just stopping people from hurting each other. That also involves creating an environment in which people do not hurt each other and have faith that that will happen. But secondly, the public at large must believe that the law reflects their moral values for the law to have legitimacy and efficacy. Therefore, it is our contention the law should be based on shared social morality. Thank you.
My name's Herbert. You can call me Herbert. And that's how Nikki Lacey, my wonderful pupil, called me in the biography she wrote about me. And she revealed in that biography that actually I was gay. And actually I kept that a terrible dark secret. And actually it was something I couldn't share with even my closest friends. And actually it's something I tried to disguise from my wife. And that was the way it was in those days. Now, AMIT Devlin speaks with silver tongue. He is a wonderful debater. He's won all these prizes. I'm just a humble, simple professor. And you know I can't really do the same as he. But basically he wants to get his grubby hands on every aspect of your private life. Listen to the list of things he wanted in the name of protecting society and in the name of social cohesion. These are the things he at different times wanted to support. Slavery, illegitimacy, blasphemy, apostasy, masturbation, adultery, bigamy, usury, fornication, rape in marriage, prostitution, not wearing your seatbelts, wearing a burqa, sadomasochism, pornography, and especially on the internet, and suicide, and marriage only for straight people. These are the rules in the name of defending the unity and cohesion of society that those of AMIT Devlin's point of view have always been advancing. They want to restrict your freedom of thought by imposing on you regulations that may, as in my humble case, affect something you want to do. They want to be very upset because someone out there is having a great time, and they don't want that, and they want to regulate it, and then, lo and behold, they want to regulate and say we do this in the name of a cohesive society, because if he gave you the truth and said we're doing it because we think you're disgusting and we don't like what you're doing, and especially we don't want you having any pleasure in what you're doing, then that might not go down so well. So wrap it up, package it, present it as in your interests, and maybe you'll go along with it. He says he's not going to talk about disintegration of society. Well, he talked an awful lot about it back in the time of the Big Mac lectures. And secondly, he said, we're only doing this for society's sake. But did you think that if you have criminal laws against these things, blasphemy, apostasy, adultery, I mean, they had criminal laws about all this. There were predecessors to AMIT Devlin. He's not alone in this long group of people who've been propounding laws to uphold morality in the name of society. When you have those laws, it makes it very difficult for people to stand up. I know, I can tell you this, I didn't really stand up. I didn't stand up for most of my life, but in the end I'd had enough, and I stood up and I gave the Big Mac lecture, and I think it's a good thing that I did. But it's important that you realise that what is done in the name of society, who is society? How dare he speak for society? Society is all of you, and society includes minorities. He says we shouldn't punish because of incest. Okay, I think also incest needs a very careful look. But is the answer to incest really to throw the adult consenting members of the family into jail? That's essentially what you have to ask. Is that the role of the criminal law? Or is it a role of something else to make sure that vulnerable people are not abused, that positions of power are not misused, that people are informed of why there is an incest taboo in society, that people are told about the problems that can arise with incest? Locking up is not a good look, and locking up is what AMIT Devlin has been very good at over the years. He's been doing it all these years, and then he sweet talks you and says, I'm only doing it for the sake of cohesion of society. Well, society's you, and society includes minorities. So, AMIT Devlin sweet talks you, but when you analyse it, his arguments are weak as putty, and vigilante behaviour. He shouldn't talk about vigilante behaviour. He's been strong on vigilante behaviour over the years, and including vigilante behaviour against people like me, Herbert. And I was the subject of the vigilantes, and I'm sick of it, and I'm free and liberated, and now I'm telling you the truth. AMIT Devlin.
The point of this debate isn't that there is one particular set of morals that are right and that those morals should reign supreme. It's that whichever consensus society can reach is the one that should govern society. And I think with respect to Herb Hart, that was a point that maybe wasn't acknowledged in his speech. So before I get to my rebuttal, I'm going to look at three arguments in my speech. Firstly, I'm going to ask the question which was paramount in this debate back in the day, about whether there are certain places that the law can't go, whether because something happens in the privacy of your own home, it means that it's beyond the reach of the law. The second thing that I'm going to look at is some of the unintended consequences of an application of Hart's approach to criminal law. And the final thing that I'm going to look at is moral relativism. But the important thing that we should recognise, following on from Mr. Hart or former Justice Kirby's speech, is that the things that he described, so as he described, a great night out, so slavery, blasphemy, masturbation, adultery, it sounds like an episode of True Blood to me. But he said, we stood in the way of you having a great time with those things. And like I said before, with the greatest of respect to our opponent, the point that Devlin made was never that there is one set of morals which should be adopted. There was never a code that he thought should be lifted and applied to people's lives. The point that he was making is that by virtue of the consensus that society reaches, those are the morals that should be applied and should govern that society. And those morals are determined by what the reasonable man thinks on the street. And that reasonable man is something that's relevant to the question that he asked about who is society. This was the second point he made. He said, who's society? It includes minorities. Those minorities are hurt by religion. And we'd say that that's precisely the point that Devlin was making in a lot of his writings. He made the point that secular societies shouldn't focus on adopting a particular theology, so a Christian base, although a lot of our laws are based upon that they now have moved on from that, and that the moral consensus reached is the important thing that governs us there. And the reason why the majority rules is by the very simple fact that that's the only way society can function and operate. We recognise that in our political systems, we recognise that in our economy, but for some reason, some people believe that the law should be beyond the reach of the consensus, of the majority there. He conceded that incest needed greater inspection, that we had to look at this point, that he said the solution isn't to lock up those people or those consenting adults, the solution must be found elsewhere. And we're really interested to know what that solution is, because from our perspective, there are two choices. You can either look for your moral code to religion, which we think is no longer applicable in a country like Australia, where there isn't one shared religion between most persons, where a lot of people aren't religious at all. So in in the place that religion previously held to instruct people on how to best lead their lives, we think that there's a role for the criminal law to play there. And so that means that you actually undermine the chances of having religious code adopted willy-nilly, because you actually look at what the consensus is amongst people of all different types. And granted, there are some people whose rights will be infringed. There are some people that won't get to have the big night out, or, to be more honest, who won't get to be in the relationships that they might otherwise want to be. But we think that that's just the reality of how society works, and that, as Amit said, society is stronger for having that consensus among its population. So I want to look at three things in my speech, as I said before. The first point that I want to look at is this question of the public and the private divide. And something that came out of the Wolfenden report was that no act of immorality should be made a criminal offence unless it is accompanied by some other feature such as indecency, corruption or exploitation. The clear rule that we took from this report and from subsequent interpretations of it was that some things behind closed doors should remain behind closed doors. And what we see very clearly on the affirmative side is that this divide has very harmful consequences. It firstly has harmful consequences for the vulnerable. And this excuse of what's behind closed doors was used to prevent the courts and governments from intervening in private homes where we saw domestic violence occurring or where we saw child molestation occurring a lot of the time, because what's behind closed doors stays behind closed doors. We have really high profile cases of South Australian judges allowing rougher than usual handling with their wives because it was within the sanctity of marriage and it was a private operation. We don't think that that's acceptable, and the principle that Wolfenden relies upon has obviously led to significant harms, and morals have shifted over time and said that that's not the way that we interpret the extent and the reach of the criminal law. Another important point to note is that what defines the public or the private realm is defined, generally speaking, by those in power and those that have a vested interest in maintaining their current dominance. So we actually think that the more that the criminal law has to do, so the greater reach that it has under Devlin's interpretation, the better off individuals will be, because there's no such thing as too far for the courts. We also think that there should be no theoretical limits to the reach of the law. And as Devlin said very clearly, the law cannot be shut out, especially indefinitely. We think that behaviours change over time and that the criminal law needs to adopt to that. And if people believe that certain acts are beyond the purview of the law, then we think that that changes the way that people interact and how they interact behind closed doors, because they know that there aren't going to be significant consequences there. The final point that I want to make here is that if private morality or immorality isn't the law's business, then why do we prevent those things that he listed? Why do we prevent things like bigamy? Why do we prevent things like polygamy or female genital mutilation? And of course, it's some of those examples, there are cases of individual harm, but a lot of them there aren't. There are many communities that would happily live in a polygamous environment. We see in Malaysia that that's often a polygamous environment. And we see that it's actually just a moral judgment that we're ultimately making at the end of the day, that we still have this as an important part of our justice system, and that if we were to change it, we think that there would absolutely be no end to what people should be able to do in certain environments. The next point that I want to make is that the harms are often worse to the individual, that there are unintended consequences to the approach that Hart takes in this type of a debate. We look at the example, we look where laws are disconnected from what the majority think. So that might be where they recognised an individual right or they didn't recognise an individual right. An example is prohibition in the United States in particular, where that led to significant bootlegging after the fact and lots of unintended consequences flew with that. Another example we can look at is abortion, especially in places like the United Kingdom and Australia, where the majority had moved on from the individual's interpretation of abortion laws there, and that when there was that disconnect between what society believed and what they were prepared to do and what the law said, you saw significant harms like backyard abortion. Of course, the modern day Hartian or the Millsian would accept that abortion was something, generally speaking, that was allowed, but we think that that debate is clouded in that environment. The final point that I want to make is an important point, and that's that there is a degree of judgment that comes when you interpret and when you propose Hart's approach to the criminal law. We think that it is one particular interpretation of the best way to live your life, that the individual is at the centre of that. But what we think societies need to do is to be able to organise themselves in ways that reflect their own particular opinions, whether that is about focusing on the individual rights or whether it is about a more utilitarian or communitarian approach like AMIT flagged. It's important to allow communities to form their own ideals rather than presupposing one approach. And that's exactly what a Devlin approach does, in that it says, irrespective of what those morals are, whether you believe that they are the correct morals, the dominant discussion within the community and consensus is what should bind that community. So with those points in mind, we think that at the end of this debate, there is ultimately still a debate left to be had, but we think that the reality is that our criminal law system does, by and large, adopt an approach that straddles both worlds. And we think that that's something interesting to reflect on in this day and age. Thank you.
She says that there are places where the law can't go. Well, I agree there are places where the law can't go, and I agree there are places where the law should go. But when you look for a criterion for making that judgment, that's what this debate is really about. And she wants to say that the criterion is what is the consensus of society. And that consensus, she says, should bind society. I suggest that the criterion is the criterion that was advanced in the 19th century, so long ago, by those great thinkers, Bentham and Mill. And they gave criteria for making the borderline decisions in these cases. And we heard the criteria at the beginning from the brilliant Dean of Law at Monash University. He said the criteria were for the defence of public order. That is, if it causes up unrest and anger and riots on the streets, well, maybe then you need some laws about it. And secondly, you need it if there is actual harm to another individual. That's the big criterion. Does it actually do harm to somebody else? Most fornication doesn't, but some may. And thirdly, you need to protect the vulnerable. You need to protect children. You need to protect people who have a mental incapacity or mental disability. And in those cases, the law, the criminal law, has a part to play. But it doesn't have a part to play to impose the views of morality of the majority otherwise on minorities or on individuals. So that is the starting point for our solution to the subject of this debate. And if we allow the views of the majority to dominate and control the criterion by which we move the criminal law with all of its great power, with its punishments, with all the machinery of the state, with the great prosecution service, with the police, and all the other oppressive mechanisms of the law. Don't underestimate these oppressive mechanisms, fellow citizens. I know about these because I know how these were brought into play not only on individual lives and not only causing individual unhappiness, but they were also brought into play, as in my own case, as Herbert in his family, by suppressing myself, by living a life of loneliness, in the well of loneliness, and by the stigma that was imposed on so many people. This is a cruelty, and it is not the proper role of the law. Well, the reasonable man or woman is a wonderful guardian of our liberties, but it's not always so. And sometimes, because of the law intruding into their minds and stopping them thinking freshly about the issue of the suppression of groups, because they feel disgust at a particular group. Why do they feel disgust? Because they never meet people of that group. Why don't they meet people of that group? Because that group is suppressed and is ashamed about itself, as I was. And I couldn't come out to my family or to my wife or to my students. I just had to have a lonely life until years later. And that's when Nikki Lacey found about it and wrote it up in my biography. She said that my view that I'm propounding sounds like a view for a big night out. Well, it's not about a big night out, and it's not about parties, and it's not about having a great time. Actually, it's about truth, and it's about love, and it's about relationships, and it's about kindness, and it's about keeping the criminal law to the things where the criminal law, with all of its great power, is needed. That is to say, dealing with problems of public order, harm and vulnerability. She talked about the case of rougher than usual punishment. Well, she should talk about that because she and her view of public morality propounded for many years that you couldn't have rape within marriage. You couldn't have it at all. It wasn't part of the law. It was a contradiction in terms. If there is rougher than usual punishment, there is harm. And if there's harm, that's a proper role for the criminal law. And therefore the criteria that I'm propounding solves that problem, whereas her criteria says, well, just leave it to the morality view of the public. That morality view of the public may be based on false assumptions and false knowledge, which it creates itself. It's a self-fulfilling prophecy. So there is a role for criminal law, there is a role for the law, there is a role in upholding social cohesion. But in matters of private morality, it's usually based on a religion, and that is not an area in which the criminal law should go, and it's therefore one which we should keep to themselves. They can keep their private views to themselves and keep their hands off our bodies and our souls. Slavery, illegality, blasphemy, apostasy, masturbation, adultery, bigamy, usury, fornication, rape in marriage, prostitution, sadomasochism, porno, suicide and marriage inequality. That's what these people offer you, but I offer you liberty. Liberty. And liberty with the protection for the vulnerable, the weak, those who are harmed, and in the cases of truly proved public order disorder. Because what they will not answer is that in the name of the consensus of society, they impose laws, generally criminal laws, and thereby try to control society questioning those laws. And if you make people criminal, if you stigmatise them, if you put them outside the law, if you make them outcasts, then they can't argue with full freedom for their point of view, and they are put down so they don't feel they can argue for their point of view, that you can't have a law against homosexuals, or that there should be marriage equality, or that you can sweep aside many of these laws. They have gone away over time because more and more people got disillusioned with them and swept them away. But they have not answered the question that when you make it part of the law, in private morality, you give it a dignity, a respect and a strength that makes it very difficult for those who want to argue for another side to actually stand up and argue, and very difficult for them to persuade their fellow citizens because, oh, it's against the law and therefore you can't do that. And that's why their basic premise is one for inaction and no progress, and that's what you'd expect. I agree that there is doubt. For example, if I'd sat on the case about sadomasochism, I would have taken the same view as the Court of Human Rights of the European Communities, that if people like to go and hit themselves and spank themselves and cut themselves, that's their business. And if it's behind closed doors and they're adults and they make an informed decision, then it's not harm, and that's their business. But there'll always be do-gooders out there. There'll always be people hovering in the background who want to stop people from doing things. Why? And I think it has something to do with aesthetics. They sort of think, well, it's disgusting, and I feel upset about it. Well, even Lord Devlin had ultimately to agree that disgust is not on the part of one person, is not a basis for founding a whole edifice of the criminal law.
I would completely agree that necessarily if laws, and that inevitably will reflect some element of public consensus because that's how they're made, will always be a step out of date, because getting that kind of mass together to influence politics, to influence legislative change, or even to funnel through to the highest edifices of the law to make law that way, takes time. And I think that that in itself is largely a good safety mechanism, because it means that momentary indulgences or individual picadillos don't become the law unnecessarily, but only when things ossify through time to have quite a lot of broad-based support do they become entrenched in laws. But as I'm sure we've heard several times, the danger of that is that people who are necessarily the numerical minority or who are the victims of social disgust will always be a step behind that as well.